Yeah, let us start. IPC, I'll start today. I have already given an overview of IPC earlier. Here, one of the most major things that you have to understand is Indian Penal Code is a penal law which contains definitions of every penal activity and then the punishment that is allotted to it. In addition to it, there is one major provision under IPC that is called as general exceptions. That means you have in IPC a provision for an act that is done not legally or against the law, but it is subject to general exceptions. There are some general exceptions that are mentioned in the IPC which form as a guard, as a safeguard against illegal or overuse of IPC. So, in order to reduce or restrict the effect of IPC on innocent people, a few general exceptions have been added. So, whenever you read an IPC section, you should always remember this IPC section is subject to, in each and every section, subject to the general exceptions. In addition to these general exceptions, there are a few specific exceptions given within the section itself. They also are added to these exceptions. So, after the exceptions are completed, then the section will start applying. So, always remember that it is not that the moment you say it is an IPC, it becomes subject to implementation and then punishment. But there are first the section minus general exceptions minus specific exceptions is equal to the implementable portion of IPC. That you have to remember. Now, what are these general exceptions? I have already given earlier, but I am trying to refresh your memory so that it becomes easier for you to understand. One of the most major things here is general exceptions is the consent. The consent is discussed in the section 87 to 92. Consent means willingness to undergo a risk. Willingness to undergo a risk which will result in a loss or a harm to a person under IPC, which is actually a crime under IPC. If it was done without consent, it would be a crime under IPC. But here, because you are consenting to it and you are an adult and you are of a sound mind and you have consented to it, then it is no crime. Okay. Then act done in good faith for the benefit of a person. Supposing a doctor is there, a patient has come or an accident victim has come. In order to protect his life, if the doctor cuts away one leg or one hand, then doctor is protected under an act done in good faith, because if he does not do it, the life of the person was in danger. But if he does it, then the life without that one particular part still is continuing. So, in order to protect the life of a person, he has done it. So, that is consent. Then another thing is you get into a lot of risky games, and there you file a scientific consent form. In adventure sports and other things, bungee jumping, things like that, you file a consent form. Now, what does the consent form says? It says that I am willing to and willingly, with my consent, with open eyes and with my mind and with the understanding of what is the probable consequences of this act, I am undertaking this activity. And if something ever happens, I am taking precautions, of course. The organizers are taking precautions, but still if something happens, then the organizers are not liable. That's the consent. So, this is how consent comes as a first defense, a valid defense. In most of the consent of the victim is the most valid defense in this case. Okay? Then, second is private defense. So, if somebody, the private defense is discussed from 96 to 106. Here, the law gives protection to those who are alert. That is the rule. If you are alert to your rights and if you fight to preserve your rights and if you take reasonable precautions in protecting your rights, the law is on your side. Supposing somebody forces himself onto you or he becomes a threat to you, he poses a threat to you or people whom you have to protect, your family members, then you have a right to use reasonable force or equal in proportionate force against the person doing so and protect your property or persons or your family members. So, imminent threat, the most important part here is that imminent threat should be there. There should be a real and here imminent at the moment an aggression and a threat to either the property or yourself or to your family members. Unless the threat is there, open and aggressive, you cannot use a reasonable force. But if it is there, then you can use a force even to the extent of killing the other person, but you will not be, it will be act as a good defense against you. Next is necessity from sections 81 to 85. It says here, in necessity, if you have to avoid a greater harm, if you have to avoid an imminent danger, supposing a truck is coming, the driver has lost his control over the truck, his brakes are not working and it is rushing against the general public in the evening, and school children are there, they are crossing the road and the truck is coming very fast and is trying to mow down the children. Now what a person, you are a policeman on the spot, what will you do? You are right if you will shoot down the driver, or you will shoot the vehicle or shoot the arm of the driver, so that you will stop the vehicle then and there. You can shoot at the tires first, then you can shoot at the arm of the driver next, and you can even shoot the driver also. So this is a necessity, because to protect many lives you are trying to kill one. Or supposing there is, you go into a zoo and animal is trying to jump into the vehicle that has gone for taking the tourists going around. So then, as a guard, you can apply electrical current, you can apply, any bullet or any other instrument to stop the animal, even though the animal is an endangered animal and it is a crime to kill it. So this is necessity. Next is mistake. Mistake is from 76 to 80, section 76 to 80. If a person believes that he is under a rightful authority or a genuine and reasonable mistake of fact, okay, that he has got the authority, he has got the responsibility, he should do something, then he does it, then it is a mistake of fact and mistake of a genuine mistake, and he doesn't have a criminal liability. The mistake negates the intention and knowledge required for an offence, because it is a mistaken. Under a mistake he does it. Okay? For example, you are in a COVID ward and you are only a MBBS completed person undergoing training, and a person is brought in an emergency period. So you think that the first option actually should be to call in your senior or somebody who is very much well versed in that particular thing. But you think that as in your new enthusiasm, being a student, a medical student, you should use your knowledge and try to protect and treat him. In so treating, you will kill the person, possible. If that happens, then you are protected from criminal liability, because you are under a mistake of a reasonable mistake of fact, that you had the responsibility, you had the responsibility, you are the only responsibility to protect him, doing whatever it is required, even though you are not competent to do it. So next is judicial acts, section 77 to 80. And a judge or a public servant who is acting in good faith or in his judicial capacity, if he does any particular act which harms a person or a property or anything, then he is protected under this. Then accident, under section 80, this exception where the act is committed by accident, not with intention or knowledge. Okay, then it is also a protection against your criminal liability. So remember, these are the general exceptions which are to be applied in each and every section. Even though the section says this particular act, you do particular act A, it is classified under section B and you are punishable with a punishment of C. That is very clearly written in IPC. But all these A, B, C are subject to X, Y, Z, all these exceptions that we have listed. Only after the exceptions your punishment will start. Yeah, now let us see what are the IPC sections under your syllabus that we have to study. And there are two things that you have to remember here. I already told you, but again refresh it. There are all crimes, all actions or all offences are divided into 4 types. One is cognizable, non-cognizable cases, bailable and non-bailable cases. Cognizable cases means a case in which the police is authorized to start investigation, to note it down and start investigation without asking for permission from the magistrate. Non-cognizable cases are those where the police have no authority to start an investigation without the authority of the magistrate. Okay, normally these are cases where the punishment is less than 2 years. If it is less than 2 years, it is non-cognizable. On a rough scale, you can remember this. If it is above 2 years, if the punishment prescribed is above 2 years, then it is a cognizable case in which the police can start an investigation. Then bailable and non-bailable. In bailable cases, it is the authority is given to the police at the police station to leave the person on bail, to release the person on bail after arrest. Those are all called bailable offences. These are again bailable offences are mostly non-cognizable offences, less than 2 to 3 years of punishment. And non-bailable cases are those where bail is to be granted after examining all the facts and witnesses available by the magistrate only, not by the police. So these are all non-bailable cases. Non-bailable cases does not mean that he will never get a bail. It only means that the bail will be granted only by the magistrate and not by the police at the police station level. So these are the two things that you have to remember. There is another called anticipatory bail. Okay, anticipatory bail is a provision where you have a here and now chance of being arrested. Then you can go to the judge in a high court and take anticipatory bail. He will give you anticipatory bail only when he feels that you are likely to be arrested. So this is now let us see the sections. All the sections given under your syllabus. First one is IPC 121A. 121A is a conspiracy to commit an offence against the state. It is mostly applied against terrorists, Naxalites, and even political, political opponents who believe in violence, like communists, etc. This is a conspiracy to commit offences against the state. It can be done by another state like Pakistan or China. It can be done by a group of people from Pakistan or China, or even a group of people within India. Okay, or Naxalites who believe in armed revolution or things like that. So anybody can be a part of that, but it is a conspiracy. Conspiracy should be not one person but more than a few persons. You may not be living in one place, you may not be living only in one area, they may be living anywhere, even all over the world also. They may not see each other, they may not know each other, but they still are all working on a particular purpose, for a particular aim, that is against the state. That is section 121A. So it addresses wage a war to overthrow the government established by law. This particular word you have to remember very clearly. Government established by law. That is very, very important in this particular section. Now later it focuses on conspiracy against the state, and it is punishable for a term of 10 years, okay, or life imprisonment, and with or without fine. And then here, what is the aim? What is the purpose? The purpose is to protect the sovereignty, integrity and security of the nation. It criminalizes activities that involve plotting or conspiring to wage war or overthrow the legally established government. Major cases that are relevant to this are: 1. State of Maharashtra versus Muhammad Yaqub Abdul Razak Memon, Yaqub Memon case 2015. Here it is relating to 1993 Mumbai bombings, one of the deadliest terror attacks in India. The Supreme Court, dealing with appeals of convicts, examined various charges including 121A. The court upheld the conviction and awarded death penalty to Yaqub Memon for his involvement in the conspiracy and other offences related to terrorism. So terrorism is one of the main aims of 121A. Second case is Arup Bhuyan versus State of Assam 2011. Supreme Court considered the constitutionality of 121A, its compatibility with the right of freedom of speech and expression under 191A of the Indian Constitution. Remember this article, it comes again and again everywhere. Article 191A. 191A deals with right of freedom of speech and expression, and there is 192 and attached to it. 192 is reasonable restriction imposed on the rights given under 191A. Always remember these two go together. So it is not the absolute right. 191A gives you the right of freedom of speech and expression, but it is not an absolute right. It is subject to the restrictions placed under 19(2). These two words, if you can remember, and it is linked to again 121A. The court held that mere membership of a banned organization or expressing sympathy for a separatist movement would not amount to an offence under 121A unless there is a direct incitement to violence or intention to overthrow the government. Here, the issue is what he says or what he does, and what is the effect of that saying or doing, and if it is going to affect many number of people who will rise up with arms and attack the government, then this saying or doing will be punishable. But if he says or does something which has absolutely no effect, and nobody rises up with a weapon and starts hitting the government, in that case his saying or doing is of no use. It is part of the freedom of speech and expression. Next case is State of West Bengal versus Kasham Ali, 2011. This case involves an appeal against conviction of the accused under various sections of 121A for involvement in a conspiracy to wage war against Government of India. Supreme Court reiterated 121A requires specific intention to wage war or overthrow the government by violence means. But mere membership of a banned organization does not establish intent and is not punishable. It is important to note that interpretation and application of 121A may vary based on different cases and circumstances. There are various Supreme Court judgments which have to be viewed. So what have we learned so far in 121A? That you see, state has to be protected. Second, states, agencies, their legal system and the system established by law, system established as per Constitution of India, has to be protected at any cost, even at the cost of punishing the person who is trying to overthrow the same. But here, overthrow of the same can be by words or deeds, and if it is by deeds, it should be with violent means, non-violent, and does not attract this provision. Under violent means, he should actually use such violence or such violent instruments which results in either harm, or there should be some action, there should be at least some attempt before he is sentenced. And if it is by words, then his words should result in many other people's to rise up in arms into an action by using arms against the state. If these two things at any given point of time actually result in an attempt or an action, then that is punishable under 121A. Next, 299 IPC. There are 299 IPC is all about homicide. Now, what is homicide? Homicide means killing of a person by a person. Killing of a human being. Homi means human being. Homicide means killing. Killing of a human being by another human being comes under 299 and 300. So, and there are other sections also following 300 and various different varieties of that. So, let us see 299. 299 is the basic one. 299 deals with the offence of culpable homicide not amounting to murder. There are two things. Homicide, that means killing of a person. Killing of a person with an intent is a murder, which has a higher punishment. And killing of a person without an intent or with something lesser than an intent, that is punishable, or an action that is lesser than one that is punishable under 300 is a homicide not amounting to murder. Culpable homicide not amounting to murder. Under the IPC, it defines circumstances under which a person can be held criminally liable for causing death of another person without the act amounting to murder. Here is a discussion of 299. IPC 299, culpable homicide not amounting to murder. According to 299, culpable homicide is defined as the act of causing death of a person if it does not fall within the definition of murder under 300. That is, all those actions that result in death of a person which are not covered or which are not accepted as being under 300 fall under 299. Simple. That means 299 is everything other than 300. 299 is equal to all killings of human beings other than those under 300 or 299. That much you remember. It includes instances of death where death is caused by with intention of causing bodily injury likely to cause death, with the knowledge that the act is likely to cause death but without any intention to cause such death, by doing an act with the intention of causing bodily injury which is sufficient in the ordinary course of nature to cause death, by administering any substance that is intended to cause death or is sufficient in the ordinary course of nature to cause death. These are the different things. Now let us see what exactly they mean. First one, with the intention of causing bodily injury likely to cause death. If I hit a person with a rod on his head, that means my intention is to break his head, and that breaking of head will definitely cause in death. So this is the first part, with the intention of causing bodily injury likely to cause death. Second, with the knowledge that the act is likely to cause death. Somebody is lying in a hospital bed and I switch off the oxygen. He has got oxygen, he is on oxygen. I switch off the oxygen supply. Okay. Now, if I switch off the oxygen supply with an intention to cause death, then I know for sure that if the oxygen is not supplied, if it does not reach the person, he is going to die. So, knowingly, if I switch off the oxygen supply, then that comes under the second equation. Now, by doing an act with an intention to cause bodily injury, which is sufficient in the ordinary course of nature to cause death. Supposing that somebody is there, I take a blade and cut his wrist. I take a blade and cut his wrist. And then my intention is to cause bodily injury. And thus, this particular act, it may, in all probability, if it is left unattended, lead to his death. And if it so happens that it is not left unattended and he dies, then it comes under 299. By administering any substance that is intended to cause death or sufficient in the ordinary course of nature to cause death. Here, supposing there is a person who has got a BP patient. He is a BP patient. So, then in that case, if he is a BP patient, then just a moment. So, by administering any substance that is intended to cause death or is sufficient in the ordinary course of nature to cause death. That means, supposing there is a person who is a BP patient and you feed him high sodium diet. Okay. So, then naturally his BP will go very high and he is going to, in the normal course, he may die. So, this comes under this fourth class. These are the four definitions under 299. Now, what are the cases? One is K.M. Nanavati versus State of Maharashtra, 1959. This case has gained significant attention and led to a landmark decision by Supreme Court in 299. It involved a naval officer, K.M. Nanavati, who shot and killed his wife's lover. The Supreme Court held, if a person causes death with the knowledge that the act is likely to cause death, but without any intention to cause death, it falls under culpable homicide not amounting to murder. Here the case was that his wife, Nanavati was a military man, his wife developed intimacy with the friend of Nanavati, and he came to know about it, and he went and asked his friend to marry his wife because he is already having an affair with her. Then that friend fellow, he said, how can I marry all the people with whom I have affairs? Because I have affairs day in and day out with hundreds of people. So when his wife was reduced to such a level of being a woman of easy means, easy availability, Nanavati lost his cool and shot his friend. So that is in short the case. And here he was not booked under 300 but under 299. Next, Virsar Singh versus State of Punjab, 1958. In this case, Supreme Court clarified the distinction between murder and culpable homicide not amounting to murder. The court held that if the act causing death is done with the intention of causing bodily injury only, and the injury is sufficient to cause death in the ordinary course of nature, it would be classified as culpable homicide. You make a cut on the wrist, and this cutting on the wrist can be broken. The chain to the cut of the wrist to death, this chain of events can be broken if the person is taken to a doctor and then is attended to. But if it does not happen and he really dies, then that becomes under only culpable homicide, not murder. State of Andhra Pradesh versus Rayavarapu Punnaya, 1976. This case dealt with the scope of IPC 299 and distinction between culpable homicide and murder. Supreme Court held that the intention of the accused and the knowledge of the likelihood of causing death are crucial factors in determining whether the offence falls under culpable homicide or murder. There should be intention of murder and there should be knowledge that his action is going to lead to death of the person. These two things should be together only to get him a murder charge. Otherwise, it becomes a culpable homicide. These cases illustrate the judicial interpretation and application of IPC and 299, determining the nature of offence and corresponding liability. So, in scope and ingredients I have already given. Now, next, let us discuss about section 300. So, is 299 understood by everybody? A response, please.
Yes, sir.
Yeah, good. Now, let's go to 300. Because these are 299 and 300 are things that you deal with under forensics almost day in and day out. So, if you understand this clearly, most of the IPC is over for you. Now, discuss section 300 IPC. Section 300 deals with murder, that means a homicide amounting to murder. 299 we led with homicide, not amounting to murder. Okay, but here 300 it is a homicide, that is killing of a person, which amounts to murder. And what we understood earlier, 299, what did they tell us? They told us that the act should be there, then there should be intention, third there should be knowledge. All these three things should together act, and then it becomes a murder. Let us see what here it says. It defines the circumstances under which a person can be held criminally liable for causing death of another person with the intention of causing death, number one, I told you already, or with the knowledge that the act is likely to cause the death of the person. These two things are together, either or together, then it is murder. Yeah, now what are the 300, what is say? According to 300, a person is guilty of murder if the act of causing death of another person is done with the following intention or knowledge. 1. Intention to cause death. If the person causes death of another person with the intention of causing death, it amounts to murder. Right? If you are angry with your neighbor, he has thrown kachra into your house, and you take a kitchen knife, butcher knife, and then rush against him to kill him, and you hit him and he dies. That amounts to murder, because your intention was to use the butcher knife against another person, and it had naturally you know as well as the other knows, everybody knows that you hitting with a butcher knife is going to kill a person. Right? Knowledge is there, intention is there, and your act also there. All three put together, it becomes a murder. The knowledge that the act is likely to cause death. If the person causes the death of another person with the knowledge that act is likely to cause death, then act is done without any excuse for incurring the risk of causing death, it amounts to murder. What is that excuse part of it? Excuse part of it is what is given under general exception. General exception, one excuse, that most major excuse that is allowed here, even though you do an act knowing that it is going to cause death, that general excuse that you do is private defense. Somebody has come and occupied your, trying to rush into your house, and he is banging the door, kicking the door, and then trying to enter, and he has got a lathi or he has got a knife or something like with him. So, in order to protect yourself and your family and your property, if you hit him, or if you shoot him, or if you use butcher knife against such a fellow who is coming into your house, then that amounts to an exception to this. So, Supreme Court decisions are there. Let us see. State of UP versus Satish 2005. In this case, the Supreme Court clarified distinction between murder and culpable homicide not amounting to murder and 299 and 300. The court held that if the act of causing death is done with the intention of causing bodily injury, and such an injury is sufficient to cause death in the ordinary course of nature, it would amount to murder. You throw acid on the face of somebody. Okay, the entire face is acid burnt, and naturally, even if attended to by the, if it is a grave injury, grave effect, even if attended to by the doctors, he or she will die. So that these two things put together, that becomes a murder. Next, Swami Shraddhananda case versus State of Kerala, Karnataka. The case involved a public figure accused of inciting violence leading to death of several individuals. Supreme Court held that for an act to fall within 300, there must be a direct causal connection between act of the accused and resulting death with the intention of causing death or knowledge that the act is likely to cause death. Here, Shraddhananda was not convicted because he has only given an appeal, emotional appeal, and that emotional appeal led to general riots. So many times we see so many Swamis are being arrested. Whenever a Swami is arrested, his followers go on a rampage on the streets, and in this rampage, a lot of property is damaged, some vehicles are damaged, buses are set on fire, and in this process maybe some individuals may also die. But this direct linkage to the person, to this particular Swamiji, that he has insight, like similar thing that is happening in, say, Pakistan now, Imran Khan being arrested, their followers have come on the streets and have set fire to many of the government properties, and there may be some people also who may have died. So in that case, you cannot say Imran Khan has killed, he's murdered that particular one individual that particular day. Okay, so this is how the link is broken. When the link is broken, then it is only a homicide. It is not linked to murder to this person. Next is Machi Singh versus State of Punjab, 1983. In this landmark case, Supreme Court laid down Machi Singh guidelines. to guide the courts in imposing death penalty for murder cases. Here he said rarest of rare cases, only in rarest of rare cases only murder death penalty should be given, or else all other murder cases you give only life imprisonment. It can be 14 years, reduce the commuted life, or it can be for the entire natural life of the person. So remember this particular punishment is given by a sessions court, but it is to be confirmed everywhere. It has to be confirmed by the High Court. To guide the courts in imposing death penalty, the court establishes a strict criteria to consider while determining the rarest of rare cases where death penalty may be warranted based on the facts and circumstances of each case. They illustrate the interpretation of 300. You see, 299 has actually is more detailed discussion than 300. That means 300 is a tip of the iceberg, and rest of the iceberg is 299. So you can always presume that in every case 90 or 80% of the times it is only culpable homicide not amounting to murder. Only in 20% cases that is a murder, and even within those 20% cases only one case maybe, which is rarest of rare case, which is liable to be punished with death, or else all others are punishable with life imprisonment for murder, and 10 years or more for all, 7 years to 10 years and more up to life, various periods for all culpable homicide not amounting to murder. Now let us compare and contrast 299 and 300 and major cases. 299, 300, culpable homicide not amounting to murder. Under 299, culpable homicide refers to causing death without the amounting to murder. That is, 299 is whatever is not 300. It includes instances where death is caused with the intention of causing bodily injury likely to cause death, with the knowledge that the act it is likely to cause death. It covers cases where death occurs due to act that are sufficient in ordinary course to cause death, act not done with the intention of causing death. And major Supreme Court cases are KM Nanavati we discussed, Virsa Singh versus State of Punjab we discussed. Next, 300, murder. Murder deals with the offence of murder more serious than culpable homicide. It involves causing death of a person with either the intention of causing death or knowledge that the act is likely to cause death without any lawful justification. Lawful justification are, I told you, private defense mostly. That is under general exceptions. Murder is an offence of a higher degree of culpability as it involves a greater level of intention, knowledge and action. Supreme Court cases are V. Satish, State of UP versus V. Satish, then with the intention of causing injury, then Swami Siddhananda versus State of Karnataka, inciting people to go on a rampage. 299 cases deals with culpable homicide not amounting to murder, focusing on cases where death is caused without a specific intention of causing such a death. Now 299 differentiated from 300, other two major cases are KM Nanavati, we read about it, and then second case is Virsa Singh and State of Punjab. Now let us see in KM Nanavati what is the details we have. Naval officer KM Nanavati was charged with the murder of his wife's lover. Supreme Court in its decision highlighted distinction between culpable homicide and murder. Court held that when death is caused with the knowledge that the act is likely to cause death but without the intention to cause death, it falls under culpable homicide not amounting to murder. The court ruled the absence of specific intention to cause death is the differentiating factor. That means when you shoot a person, if your intention is to kill him only, but if you are shooting a person in your frustration, but it hits in a particular place where he dies, then that is culpable homicide not amounting to murder. So when your wife is at stake, your wife's chastity is at stake, and the other person he acts in such a nonchalant manner, it is normal for a person to get worked up and shoot. And this particular shooting is only culpable homicide and not murder. This case marked a significant development in legal understanding of culpable homicide and murder. It established the principle that an act amounting to murder under 300, there must be a specific intention to cause death, where culpable homicide under 299 can be established when death is caused with the knowledge that is likely to cause death but without the specific intention to do so. Virsa Singh versus State of Punjab 1958 differentiated murder, culpable homicide not amounting to murder 299 versus murder. Supreme Court in judgment highlighted the significance. Court held that if the act causing death is done with the intention of causing bodily injury and the injury inflicted is sufficient in the ordinary course of nature to cause death, it would amount to culpable homicide not amounting to murder under 299. However, the act is done with the specific intention of causing death, it is 300. Supposing you throw acid on a person. The acid on a person, the intention is only to disfigure. Intention is not to cause death. But supposing he is not left unattended and then that person dies. then it comes under 299 only and not 300, because the intention was not to cause death but only to disfigure. The case emphasized that the specific intention to cause death is a distinguishing factor between the two provisions. It established that when the intention is to cause bodily injury, the resulting injury is likely to cause death, but not specifically intended to cause death. It falls under culpable homicide not amounting to murder. Okay. Next, let us see 302. Everywhere we find that 302 is referred, not 299, 300 we rarely hear. But actually 299 and 200 are the real provisions. 302 is only a provision for punishment. It is a punishment section. 302 deals with the offence of murder under IPC. It defines the act of causing death of another person with intention or with knowledge and in discussion. 302 murder, according to 302, whoever commits offence of murder shall be punished with death or life and liable to pay a fine. Here, murder is considered to be heinous offence and dealt with an utmost seriousness in Indian legal system. Now, what are the cases? Bachchan Singh versus State of Punjab, we already read it. Rarest of rare case doctrine has been imposed. So nowadays, all over the world also, there is no death penalty. Many countries have outlawed the death penalty. But in India, death penalty still is there. But it is to be applied Supreme Court under Supreme Court order under Machi Singh case. That it is to be applied only in case of rarest of rare cases, not otherwise. And you have to justify. The person who is giving a death penalty, the judge has to justify why he thinks it is a rarest of rare case. Give 1 to 5, 6, 7, 10 reasons, and then link it to the particular case, and then say why it is rarest of rare case. So the only case where rarest of rare case was applied was under Bombay. People who have come from Pakistan and killed many people in Taj in Bombay. That was one rarest of rare case. The other was one where the sexual abuse and killing of a girl in Delhi. That case. Okay, so these are the two things they come under rarest of rare case to understand. And next is State of Rajasthan versus Jagu, 2010. Supreme Court dealt with the issue of circumstantial evidence in murder cases. You are remember that forensic evidence comes under circumstantial evidence in murder cases. Your role is mostly under the circumstantial evidence in murder cases. The court emphasized that in cases based on circumstantial evidence, circumstances must be proved beyond reasonable doubt and they must point to the guilt of the accused with no other explanation. These Supreme Court decisions have had significant impact. Okay, next. This is 302 is over. Next, 304A IPC and major cases. 304A deals with offence of causing death by negligence. So, up to 299 is only culpable homicide, 300 is murder, 302 is the punishment for murder, and after that, these are all the lesser varieties of killing a person. Lesser varieties. Their punishment is lesser and lesser and lesser after 302. So now 304A, it is causing death by negligence. That means you are negligently driving on a vehicle on a road and going very fast when the road is very narrow and you hit another scooterist, a lady scooterist, and that lady dies on the spot. That is causing death by negligence. Because you are not supposed to go so fast on a road which is narrow, and that too not apply a brake when another two-wheeler is coming in your way. So it applies when a person causes death of another person by negligent act like rash or reckless. So normally it is called as rash and negligent driving. Causing death by rash and negligent act, driving is called. That is the wording that is used. That comes under 304A. 304A focuses on cases where death occurs due to absence of proper care and caution rather than the intentional act. Okay. Negligent act, it is a doing rash or negligent act not amounting to culpable homicide shall be punished for 2 years or with a fine or both. So if you cause death of a scooterist by driving very fast when the light is between yellow and red or just turn to red and you wanted to jump that red light and in between the person who stopped before you is a scooterist and you hit her and you go ahead, and that amounts to this particular clause of 304A. R.K. Dalmia versus Delhi Administration 1962, Supreme Court emphasized the element of negligence in cases falling under IPC 304A. The court held that the act causing death must be both rash and negligent, meaning it should be departure from the standard of care expected from a reasonable person in such similar circumstances. Always remember, the standard used is a reasonable person standard. And entire IPC the standard of care and the standard of due diligence and standard of particular, benefit given to is based on a reasonable person's actions. What a reasonable person in similar circumstances would do. If you don't do it and you cause a death or get homicide or you do any particular act, then IPC it becomes punishable. Remember that. So it is a reasonable person standard that is there. The court clarified that the mere negligence without a rash act would not attract 304A. Only negligence is there, rash act is not there. You come to a stop, but still it hits another scooter. Okay, it is a rash act, but there is no negligence is there. You have applied your brakes and you stopped, but yet the person is hit and that lady goes and hits a divider with her head and she doesn't wear a helmet and then she dies. Get the idea? So in that case 304A is not retracted, it will be much lesser. Jacob Matthew versus State of Punjab 2005. This case highlighted the distinction between ordinary negligence and gross negligence in case of medical negligence resulting in death. Supreme Court ruled that in case of medical professionals causing death due to negligence, higher degree of negligence is required to hold them criminally liable under 304A. Court emphasized that criminal liability to be established, negligence must be so gross as to indicate reckless and wanton disregard for safety and lives of others. So you see, you are operating a person and you leave your scissors within the body cavity of that person and then stitch him up and go. And that leads to some consequences and the person finally dies. This is a gross negligence. But you are operating on a person, you do the stitches, but you do the stitches wrongly. Or your stitches do not stay and your stitches will break due to whatever reason. And that is not a negligence. That is negligence, agreed, but it is not gross negligence punishable under 304A. So indicate the reckless or wanton disregard should be there. You should not care whether a person dies or lives. That is wanton. Suresh Gupta versus Government of NCT Delhi 2009. Supreme Court addressed Section 304A in cases involving road accidents. Court clarified that mere involvement of a road accident resulting in death would not automatically attract 304A. I gave you two situations. The act causing death must be a result of rash and negligent driving, and there should be a clear departure of a reasonable person's standard of care. Okay, you hit a person and you go very fast, 100 speed, and you hit a two-wheeler, and that person, because of the hit and hits on your car as well as the road and then dies, then that is rash and negligent driving resulting in death. But supposing you come to a stop, then also that hit is there, but that lady hits the divider, she doesn't wear a helmet, she hits a divider and then causes a head injury and she dies, then that does not attract 304A. The Supreme Court cases have provided important interpretations. Now next, 304B. 304B deals with the dowry death. It aims to address the social evil of dowry-related violence and death of women. 304B provides for specific provision to deal with cases where death of a woman occurs within 7 years of her marriage. Remember, marriage M+7. M+7. Within this period, if within this period a person dies, a lady dies under suspicious circumstances, even though she may have committed suicide also, this comes under this particular 304B. It is a specific provision to deal with cases where death of a woman occurs within 7 years of marriage. It's shown that she was subject to cruelty or harassment by her husband. She might have written letters, she might have told the neighbors, or neighbors must have overheard. Either of these three things happens, or on her body there are proof of mistreatment, ill treatment by her family members, and then there is proof that demand for dowry is there, things like that, then they come under 304B. Dowry death. Okay, suspicious circumstances should be there. What are the things that are required under 304B? 1. Death should be there, number 1. Number 2. It should be caused by unnatural means, not natural death. Unnatural means can be burns, it can be bodily injury, it can be any other suspicious circumstances, and then it should be within 7 years after marriage, and then there should be proof, prior information that cruelty is there, harassment is there for dowry, and it shall be deemed to be a dowry death, and the offence is punishable for a term shall not be less than 7 years, may extend up to life. Supreme Court cases are there. Kaliya Perumal versus State of Tamil Nadu 2003. Supreme Court emphasized importance of proving The death of the woman occurred under unnatural circumstances, that she was subjected to cruelty or harassment for dowry. The court clarified that both these elements must be satisfied. That means subjected to cruelty number 1, second harassment for dowry number 2. Both should be there, plus 3 it should be beyond reasonable doubt to convict the accused under 304B. Three elements are there. What is that? Within 7 years, unnatural circumstances, cruelty, harassment for dowry, established beyond reasonable doubt. These are 5 people. 5 things are there, then it is 304B. Satvir Singh versus State of Punjab 2010. It is soon before her death under 304B. Supreme Court held that the expression soon before her death implies that there should be a reasonable connection between the cruelty or harassment for dowry and the woman's death. Only then it will be soon before her death. That wording is there. Court held that the demand for dowry and the cruelty inflicted on women should not be too remote in time to establish 304B. That means she was married, and the marriage, within first 6 months of marriage, there was cruelty, harassment, etc., etc., demand for dowry, everything is there. First 6 months is very, very turbulent in any married person's life. But after that, things settle down, all people have come together, elders have come together, set things right, and settle down, and on the 6.5 years, at the almost nearing 7 years, the lady dies. And that too, unsuspicious circumstances, or lady commits a suicide. Now you can go back and quote what happened in the first 6 months of marriage, saying that there was a demand for dowry and harassment or cruelty, and that has led to her death. So this is called too remote or soon before death. The difference is like that. Time is the essence. Within which time, how many months before death, these are things that are very relevant here. In Rajinder Singh versus State of Punjab 2015, Supreme Court clarified that the ingredients of 304B must be proved independently of the general principles of criminal law. Okay? Because there are special things there. You see, normal general principles of criminal law is intent, mens rea, actus reus, things like that, causing death, knowledge that it will cause death, an act that will likely to cause death, things like that. Independent of that, in 304B you have specific things. Demand for dowry, cruelty, that too soon before her death, and things like that are there. Suspicious circumstances, suicide. Okay, all these things should be established independently of the general principles of criminal law. Court highlighted that prosecution must establish a woman subjected to cruelty and harassment for dowry, and that her death occurred under suspicious circumstances. There should be a linkage. Court emphasized mere suspicion or conjecture cannot lead to 304B. Okay, now 304B has been to a large extent diluted now at the moment by court decisions. Court judgment ensured provision is applied appropriately. Appropriately means they don't want many people to be convicted under this. That is called 304B is also over. 304A over, 304B over. Next is 307 IPC. What is 307? 307 is not murder as such, but an attempt to murder. From 299 up to 306. 299 to 306 are instances where there is a successful attempt, successful act leading to death of a person. But under 307 it is an attempt to murder. It is not really, the act is not completed. The other person is not dead, but he likely would have died. Something has intervened and he survived. Okay, it covers situations where a person with the intention of causing death commits an act that is likely to cause death, but falls short of actually causing death. You hit him with a rod on his head, sir pad gaya, then he goes and he is taken to a hospital, and then the doctors succeed in restoring him back to health. So that is called attempt to murder. Attempt to murder is serious offence, punishable under IPC. Okay. Here it is up to 10 years, it can be any period, and liable to pay fine also. Now, what are the cases? Cases Nanavati again, Rajasthan versus Om Prakash. 307 discuss the level of intention required for the offence. What is the level of intention? That gradation. That is what required discussed here. Court held that the intention to cause death or to cause such bodily injury likely to result in death must be present for the commission of the offence. Mere knowledge that the act is likely to cause death or cause bodily injury is not sufficient to attract 307. You know that it is likely to cause death, but it is not sufficient. You should have an intention to do that particular act, knowing that particular act is going to cause death, and you do it with that particular full 100%, 90%, 80% intention, and then you do it, then that comes under 307. But you merely, if somebody crossing a railway lane, you know that at that time express will come and it will hit him. But you encourage him to cross the line. And he crosses and it is hit by the railway line, train, and then he dies. And then it cannot be, you cannot bring it under 307. Because level of intention is only negligence. Okay, jaan do yaar. He should know what he is doing. Let him go. Hit hota hai to hone do. Mujhe kya hai? That kind of thing will not come under 307. Harjinder Singh versus Delhi Administration 1999. Supreme Court discussed the concept of overt act. There can be a covert act, there can be overt act. Overt act means that which can be seen by others, that which can be given as a witness by an eyewitness. That is overt act, seen outside the body it is seen. Covert act is it is not seen, it is only implied. The court held that for an act to be considered an attempt to murder, there must be an overt act, that is a direct step towards commission of the offence. Court emphasized mere preparation, contemplation will not constitute an attempt unless there is an overt act, a clear intention with the intention to cause death. Okay, you buy a cookery and keep it in your house. Okay, and then you find out all the literature, how to use the cookery, how to kill a person with a cookery. But you finally don't use that cookery to kill a person. It will not be an attempt. It has nothing to do with an attempt. It is only buying a cookery, that's all. It has nothing to do with 307. Next is 309 IPC. 309 IPC deals with attempt to commit suicide. This is a very, very tricky section where you not only lose your life, but you are also likely to be, if you fail to die. When doing suicide, the joke is, if you succeed, you are punished with death by God. If you fail, the court will punish you. So either way you will be punished. That is 309. The joke of 309 is that attempting at 309 will result in definite punishment. If you succeed, it is death penalty by God, and if you fail, it is a penalty by the law, which may amount to anything, depending on what is the level. Now it is important to note that this section has been widely debated and criticized, for criminalizing an act involves an individual mental health and well-being. Oh, pagal ho gaya, depression mein hai, jumped into the well. He had a lot of bad happenings, bad luck, ill luck, loss of money, loss of property, loss of wife, loss of family, and he becomes deranged and he jumps into a well. Then you take him and put him behind bars and punish him for 7 years. It becomes really a joke of a judicial process. So that's why people are against this particular section. 309. Whoever attempts to commit suicide and does any act towards commission of offence shall be punished with simple imprisonment of 1 year or fine or both. Now what are the cases? Gyan Kaur versus State of Punjab 1996. In fact, in these cases, instead of imprisoning him for 1 year, he should be sent to some mental institution where his mind will be brought back to living. Give him some interest to live. Give him some reason to live. Then automatically he will come back into normal course, instead of putting behind bars for 1 year. That's the normal discussion that happens. Gyan Kaur versus State of Punjab. IPC 309 was challenged before Supreme Court. Court upheld the validity of the section and held the right to life under 21 does not include right to die. But nowadays there are a lot of judgments which have given the right to suicide also, right to die, Ichha Maran. Ichha Maran has now been upheld. There are some instances, some rules and regulations, some procedure where you can attempt to die, you can opt to die. That's also there nowadays. The court observed that the sanctity of life is paramount and the state has a legitimate interest in preserving life and preventing suicide. You may have interest, but it's not the same thing as punishing. Aruna Ramchandra Shanbag. Aruna Shanbag was Union of India. It is a very famous case, 2011. Did not directly address 309. It has significant implications for euthanasia and the right to die with dignity. The Aruna Shanbag case is a right of euthanasia and right to die with dignity.
Supreme Court has now recognized the concept of passive euthanasia, allowed for withdrawal of life support in certain circumstances. However, it did not address the criminalization of attempted suicide under 309 because that question was not put to the court in this particular case. The case was about euthanasia and how to die with dignity when a person is living a vegetative life and only on support of medical instruments. Otherwise, there is nothing called life in it. In such cases, only passive euthanasia is allowed. That attempted suicide was not under question under 309. Maybe some other case will come. Common cause versus Union of India. Next, Supreme Court revisited the issue of passive euthanasia and right to die with dignity, recognized the right of a terminally ill patient to refuse medical treatment or life support in certain situations. Court did not specifically address the validity of 309 or criminalization of attempted suicide. It has been a growing recognition that the need to decriminalize attempted suicide and provide mental health support to individuals in distress. Several mental health professionals, activists and organizations have advocated repeal of 309, arguing it hampers mental health intervention and stigmatizes individuals struggling with mental health issues. और पहले से ही इतने दुख में है बेचारा, उसको फिर ले जाके जेल में डालोगे तो it doesn't look nice. It is not civilized behavior. It is not how civilization should function. That is the objection. Worth mentioning that the Mental Health Care Act 2017 came into force in India, decriminalizes suicide. There is this new act, is that Mental Health Care Act 2017 has decriminalized suicide, provides for mental health care, so it is anti-309. This Mental Health Care Act is therefore anti-309. 309 has been now watered down to such an extent by one, euthanasia, second is Mental Health Care Act. So it has been addressed. Our concerns have been addressed. Yeah, next is 319 IPC. 319 deals with offence of causing hurt that endangers life or causes grievous hurt. Hurt and grievous hurt. Hurt is simple hurt. You cause any pain, anything that is causing a pain to a person is hurt. And anything that is more than causing a pain to leading to chances of death is grievous hurt. It covers situations where a person causes injuries to another that are severe enough to endanger life or cause grievous hurt. Endangering life is grievous hurt. Now, section 319, hurt endangers life or causes grievous hurt. 319. Okay, in punishment is 7 years and plus fine. Now, what are the cases? Bhura versus State of Rajasthan 2010. Supreme Court held that for an offence under 319 to be established, it is not necessary to prove that the injuries inflicted by the accused were likely to cause death. It is sufficient if the injuries caused endanger the life of the victim or cause grievous hurt. And these injuries need not directly, because I take a blade and cut your skin at various places, supposing. In an altercation, we are having a fight and I have a blade and I take the blade and cut on various places in the body. These are the items that cause hurt and grievous hurt, but they are not likely to lead to death unless no medical attention is there. So that kind of a thing is not 309. Okay. Joginder Singh versus State of Punjab 2012. Supreme Court reiterated that to establish the offence under 319, necessary to show that injuries caused to the victim are sufficient to endanger life or cause grievous hurt. Clarified that mere superficial injuries of a minor nature, are not 319. I told you just now, making cuts on skin, any number of cuts, is not 319. Maniram versus State of Uttarakhand. In this case, Supreme Court discussed the distinction between hurt that endangers life and grievous hurt. Held that for offence under 319, it is not necessary to prove both endangering and grievous hurt. Either endangering or grievous hurt is sufficient. That is slightly more stricter version. The Supreme Court cases have provided guidance, clarified offence, hurt, grievous hurt, endanger to life, and things like that. Next, section 320. 320 is grievous hurt. The following kinds of hurt are only designated as grievous hurt. First, emasculation. Emasculation means almost सिर्फ हड्डियाँ रह गई हैं और कुछ नहीं है. इस आदमी में हड्डी बच गया है और कुछ नहीं है. That is emasculation. Doesn't have any muscle mass at all. He has been fasting for days together. He has not been given food for days together. That is grievous hurt. First is emasculation. Second, permanent privation of the sight of the either eye. is unable to see with either of the eye, one eye, that is grievous hurt. Thirdly, permanent privation of the hearing, he is unable to hear from at least 1 year. Then privation of any member or a joint of the body, member of the body or joint of the body, he is unable to lift his hand, he is unable to lift his leg, that is next. Fifthly, destruction or permanent impairing of the powers of the member or a joint, he is unable to hold, catch, walk, things like that, permanently. Then permanent disfiguration of the head or a face, acid dal diya, pura head or a face has become disfigured permanently. Then fracture or dislocation of a bone or a tooth, एक घूसा मारा, 10 दांत निकल गए. So that is then you hit him on the hand and the hand is broken. This is things. Next, any hurt which endangers life causes sufferer to be during the space of 20 days. Here the essential point is you should be hospitalized with that particular injury for a minimum period of 20 days. 20 days is very, very crucial. If you are there for 20 days in a hospital or under a pain, then it is grievous hurt. Supposing हाथ टूट गया, plaster डाल दिया, you are in pain for 20 days, that is grievous hurt. Under IPC 320, section defines, enumerates types of grievous hurt. Now, 320, following kinds of grievous emasculation causing permanent deprivation of the male reproductive organs, that is also possible. Permanent privation of the other eye causing permanent loss of vision of one eye. Privation of the ear, is one ear not unable to hear. Then privation of a member of joint causing amputation or loss of a limb or a joint. Destruction or permanent impairing of powers of member of joint causing severe damage, impairment to any limb or joint. Permanent disfiguration of the head or face causing severe permanent disfigurement of head or face. Fracture or dislocation of a bone or both. Okay. Any hurt which endangers life and causes sufferer to be in severe bodily pain for a period of 20 days and renders unable to follow his ordinary pursuit. Important to note, these categories of grievous hurt are not exhaustive, and then courts may consider other injuries as grievous. Now, what are the cases? Bhupendra Singh versus State of Punjab 2011. It is an incident where the accused caused grievous hurt to the victim by hitting him with a blunt weapon. Supreme Court affirmed the conviction, emphasized seriousness of grievous hurt. State Haryana versus Rajaram 2011. Accused caused grievous hurt to the victim by attacking him with a sharp weapon. The earlier one was blunt weapon. This is a sharp weapon. Supreme Court upheld the conviction and clarified the parameters for determining the nature of injuries and categorizing them as grievous hurt. In Dinesh Kumar versus Rajasthan 2019, case dealt with an incident where the accused caused grievous hurt to the victim by assaulting him with a knife. Supreme Court analyzed the nature of injuries and implication for categorization of grievous hurt. Dinesh Kumar versus State of Rajasthan. If you have time, you read this Dinesh Kumar versus State of Rajasthan because they deal with the nature of injuries and their analysis. That you will come across in your profession if you are under forensics, various places. Next, 324 IPC. 324 IPC deals with voluntarily causing hurt. Earlier 319 was grievous hurt. 324 is only hurt by dangerous weapon or means. Here the emphasis is on dangerous weapon or a dangerous means. Hurt is only normal, but what is used to cause it is a dangerous weapon or a means. That is the difference between 319 and 324. It covers situation where a person intentionally causes hurt to another person using a dangerous weapon or a dangerous means likely to cause death or grievous hurt. Okay, here is 3 years and plus fine or both cases. Lakshman versus Maharashtra 2002. That under 324, it is essential to prove that accused voluntarily caused the hurt to victim using a dangerous weapon. Dangerous weapon or dangerous means used by accused must have the potential to cause death or grievous hurt. It may not result in death or grievous hurt, but it has the potential. Next, Ram Kumar versus State of Haryana 2015. Clarified offence under 324 is a specific offence and does not require proof of a specific intention to cause death or grievous hurt. Intention to cause or death is not necessary. Only the offence and then the hurt, whatever injury, that is sufficient. It is sufficient if the accused voluntariness should be there, injury should be there, hurt should be there, dangerous weapon should be there, and this dangerous weapon must be capable of causing death or grievous hurt in any other particular situation. State of Rajasthan versus Parmanand 2014. Supreme Court discussed the concept of dangerous weapons and means under 324 held that the term dangerous weapons should be interpreted broadly and includes not only weapons traditionally considered dangerous but also any other means that can inflict serious harm or injury to a person. The Supreme Court cases have provided important interpretations. So what are the things? Dangerous weapons we know, all the big knives, butcher knife and arrows, gun, pistol, revolver, things like that. These are all we know. What can be the one that is not traditionally, that can inflict serious harm? One example can be you deprive him of oxygen. Just put a plastic cover on his face and hold it tight so that he doesn't get sufficient oxygen, or he is already under oxygen and you switch off the oxygen flow. Things like that can come under this. Section 326 IPC. 326 deals with voluntarily causing grievous hurt. 324 was voluntarily causing hurt plus dangerous weapon. And here 326 is voluntarily causing grievous hurt plus again dangerous weapon or means. Again, that's slightly a higher version of 324. Okay, here the punishment will be life imprisonment or fine or both. Cases are Kameshwar Singh versus State of Bihar, 1998. Supreme Court held under 326 to be established necessary to prove the accused voluntarily caused grievous hurt to the victim using dangerous weapon or likely to cause death. Court reiterated element of intention is crucial in establishing the offence. Bhagwan Singh versus State of Madhya Pradesh, 2002. Court held injury must be of such a nature that it endangers the life or causes permanent disfigurement or loss of a particular member or a sense. Gravity and severity of the injury is very important here. State of Madhya Pradesh versus Gorelal Yadav. Supreme Court emphasized the seriousness of offences under 326 and need for imposing appropriate punishment. Court should take a stern view of cases involving grievous hurt and ensure offenders are appropriately punished. No lenience should be shown. That's what it means. These Supreme Court cases have provided important guidance. Next, 326 IPC. 326 IPC deals with the offence of voluntarily causing grievous hurt by dangerous weapons. We have already seen that. Okay, I think it is repeated here. Maniram, Bhagwan Singh, Bola Singh. Okay, no problem. Next, 351 IPC. 351 deals with the offence of assault. Assault means, see, there are two words, assault and battery. I wave my fist, a clenched fist, near your face and eyes and give a move as if I am going to hit you. That is assault. I have not actually hit you, but I am threatening you. That is assault. But I actually hit you, then it is battery. That means till my clenched fist comes up to your face, it is assault. The moment it lands on your face, it becomes battery. So, in India, we don't use the word battery, you use the word called criminal force, use of criminal force. That much you remember. Assault and battery are universal terms. Battery is not used in India, criminal force, use of criminal force is used in India. Section 351 deals with the offence of assault. It covers situations where a person intentionally assaults another person without causing any grievous hurt. Okay, there is intention is required, assault is required, without causing grievous hurt is also required. Punishment is 3 months plus fine of 500 rupees. Ganesh Prasad Singh versus State of Bihar. Supreme Court emphasized offence 351 is to establish there must be intentional act of assault. Mere scuffle, minor physical altercation does not come under 351. Suresh versus State of Tamil Nadu, 2007. Assault implies intentional use of force or threat of force on another person. Court clarified mere words or gestures without any physical act would not amount to assault under 351. Ramkumar Pandey versus State of Jharkhand, 2012. That intentional act plus causes apprehension of harm plus creates a reasonable fear of injury is 351. It's a deliberate act of aggression. Okay, it may not have actually caused, but it creates that image in the mind of the victim. Then it is assault under 351. Then 354 IPC. 354 deals with the offence of assault or criminal force to a woman with an intent to outrage her modesty. Here it is outraging the modesty of a woman is the issue. 351. But for that purpose, use of a criminal force, assault or battery with an intention to outrage the modesty of a lady is 354. where a person intentionally uses force against a woman intending to outrage her modesty. 354. The punishment here is 2 years or fine. Cases are State of Punjab versus Major Singh 1967. Supreme Court held that offence under 354 requires proof of two elements. 1. Assault or a criminal force. Assault or battery on a woman. 2. Intention to outrage her modesty. That is, the assault is physical part, that is actus reus, and mens rea is the intention to outrage her modesty. The intention to outrage modesty is a crucial factor in determining whether it is under 354 or 351. State of Maharashtra versus Madhukar Narayan Mardikar 1991. Modesty under 354 is related to a woman's dignity, privacy and decency. Outraging or modesty में modesty क्या होता है? Then that is related to dignity, privacy and decency. Okay. Then HP versus Mangatram 2008. The court held the victim's statement carries significant weight if it is found reliable and trustworthy. It can form the basis for punishment. Victim बोल दिया तो बस है अंदर गए. Next 359 IPC kidnapping. Under IPC, kidnapping is addressed under 359 to 369. The sections deal with various forms of kidnapping and prescribe punishments for the offence. Kidnapping 359. Whoever kidnaps any person from India or from lawful guardianship shall be punished with 7 years plus fine. There are two types of kidnap here. One, kidnap from India itself. Second is kidnap from the lawful guardian, from his guardianship. Supposing a mother, divorce case is there, mother and child are living in a place and the father is living abroad. If the father comes surreptitiously and takes the child away and goes to America, it is kidnap of the first part, kidnap from India. Second, he takes that girl away to his parents' house and then keeps that girl in the parents' house. Takes from the lawful guardianship of the mother, a small child is kept in the parents' house. That is come under from the lawful guardianship. Kidnapping from lawful guardianship 361 IPC. Offence of kidnapping a minor below 16 years of age from lawful guardianship. Punishment is 7 years plus fine. The focus is on taking or enticing away a minor from a lawful custody of their guardian. Next. 364. Kidnapping or abducting in order to murder. This is a much serious criminal kind of thing. Section addresses the offence of kidnapping or abducting a person plus intention to cause murder. Prescribes punishment of death or life or fine. Then 364A. Kidnapping for ransom. This is a human trafficking cases and criminal cases. Section pertains to offence of kidnapping a person for ransom or for unlawful gain. Punishment of death or life or fine. Kidnapping or abducting in order to subject a person to grievous hurt or slavery. That is called human trafficking. 365. Kidnap or abduct a person with intent to put him for grievous hurt and slavery or other form of exploitation. बच्चों को ले जाते हैं, उसका हाथ पांव काट देते हैं, उंगलियां काट देते हैं, नाक काट देते हैं, आँख में एक आँख से अंधा कर देते हैं, so that he becomes eligible for pity and begging. This all comes under this particular section 365. The punishment prescribed is imprisonment of either description of 10 years or fine. Kidnapping or abducting with intent secretly and wrongfully to confine a person. 368 IPC. Kidnap or abduct a person to secretly put him in one place or wrongfully confine him. Normally this is done to collect dues or in cases of love affairs, things like that. And then it is punishable with 7 years with fine. Now cases are State of Maharashtra versus Madhukar Narayan Mardikar. We discussed again. Protect the rights of children and punishing offenders. Minor girl. Vishal Yadav versus State of UP. High profile Nitish Katara murder case where accused was convicted for kidnapping and murder. Then Rajasthan versus Mukesh and other. Infamous Bhavari Devi murder case where accused were convicted for kidnapping and murder. It is highlighted for heinous nature of the crime and the role of judiciary in delivering justice. Next is 362 IPC, major case of Supreme Court. 362 deals with abduction. Earlier was kidnapping, this is abduction. It covers situation where a person by force or deceit compels another person to go from any place. See, how do you differentiate between abduction and kidnapping? Kidnapping is that element of force or deceit is not there. You may only do very non-violent method. Kidnapping is a much non-violent method of taking a person away, whereas abduction is a violent method of taking a person away. These are the two differentiation that you have to remember. It compels a person to go from any place. Okay, abduction by force, compels, or by deceit induces to go from another person is called abduct. Case is Maharashtra versus Chandra Prakash Kevalchand Jain. Supreme Court said essential elements of abduction under 362 are: 1. Use of force, 2. Deceitful means, plus compelling a person, plus moving from one place to another. Both force and deceit are important here. State of Rajasthan versus Vidyavati 1991. Requirement of compulsion in abduction cases. Here it was discussed. Use of force, deceitful means must result in the person being compelled to go against their will. Mere persuasion, mere enticement is not 362, it comes under 361. It is kidnap, not abduction. Vishnu versus Maharashtra 2006, Supreme Court clarified, abduction can occur even if the person is induced or compelled to go a short distance or to a nearby place. अपने घर से बाजू के घर में ले जाओ, that is abduction. बाजू के घर में, neighbor's house also, that is also abduction. Crucial factor is use of force or deceit to cause a person to move against their will. These Supreme Court cases have provided important interpretation. Next, 375 IPC. 375 IPC deals with offence of rape. This 375 you have to understand very clearly. You must read the section fully, because these cases, they form an entire one class of cases. A lot of forensic activity is linked to this offence of rape. A man is said to commit a rape if he engages in sexual intercourse with a woman under certain specified circumstances without her consent, or when consent is obtained by force, fraud or coercion. Nowadays 375 has again added, lot of things are added, lot of discussion is there. Actually it takes a lot of time to discuss only 375, but still suffice it to say, okay, here it is rape is a man to a woman, okay, without consent. And it can be by way of force or a fraud or a coercion. Cases are State of Maharashtra versus Madhukar Narayan Madikar, we discussed earlier. Punjab versus Gurmeet Singh. In case of rape, the sole testimony of the victim is sufficient to establish the guilt of the accused, if it is found credible, reliable and inspires confidence. Court recognized the reluctance of victims to report rape due to social stigma. Rajasthan versus NK, year 2000. Supreme Court discussed the concept of consent in case of rape. Court held consent must be given voluntarily without any fear, duress or misconception. Absence of resistance does not imply consent. That is most important, you have to remember. Many times the defense argues that there is no resistance, means it was willingly consent is given. But court has clearly said, unless the consent is overtly, vocally and clearly given, it is no consent. No resistance is no consent. It is essential to consider totality of circumstances. Then 377 IPC. 377 deals with unnatural offences. Unnatural offences are sex with animals, sex in other than normal course, normal method. These are all called unnatural offences. It criminalized consensual sexual activities between individuals of same sex, or between two males or two females. This in 2018 judgment decriminalized adult consensual homosexual activities by declaring 377 as unconstitutional. Okay, 377 is now unconstitutional as far as the man to man or woman to woman, but still intercourse between humans and animals is still under this 377. Navtej Singh versus Johar versus Union of India. Supreme Court declared 377 unconstitutional to the extent it criminalizes consensual sex between adults of the same sex. Court held 377 violated fundamental rights of individuals, including right to equality, privacy, dignity. Supreme Court decision on Navtej Singh Johar decriminalized the same-sex relationship, recognized the rights of LGBTQ community. LGBTQ is All those other than completely 100% male, 100% female, normal individuals, all of them come under LGBTQ. And emphasize that the sexual orientation is an inherent aspect of individual identity and should be protected under constitutional guarantees. Navtej Singh Gohar case enacted significant step in recognizing and protecting LGBTQ community, promoting inclusivity and fostering a more progressive and tolerant society. So these are all the discussions we have made under IPC, all the sections that are there in your syllabus. So that comes to an end when next class tomorrow at 6 p.m. we'll discuss about the Indian Evidence Act cases and then try to see what can be done. Any questions, please? Yeah. Please, I have already put up the material in your WhatsApp group. Please download. Please download and read. Read the sections also. All the sections that I have written. I have given only the discussion and cases in my law PDF. I have also given IPC itself, complete IPC. Take each of the case and just read one, because this is a very, very crucial subject, very, very crucial law, and you must know each and every section, what it exactly entails. What you have to see in a section is, what is that section, what does it make it illegal, what are the contents which make it illegal, which comprise of it, elements of that crime, and what are the exceptions, what it is not. What it is less important than what it is not. What it is not is much more important. Unless you know what it is not, you will not clearly understand what it is. And in all these books and acts also, a lot of explanation is given. So it will help you by and by.